was an additional, I know this was an additional meeting, and I appreciate all of you adjusting your schedules to make this. This is our last meeting of 2022. I wanted to just, we're going to be hearing today from our Department of Health colleagues and having a discussion after that around what we've heard from them. And I think just to sort of level set, I was thinking about this today, you know, if you're not a state employee, this process probably seems a bit bizarre and very slow moving. And I think just to kind of refresh sort of our sort of state agency purpose here is we are responsible for responding to the language, the proviso language in the budget. We have some deliverables that we are required to respond to. So Senator Solomon can move forward with the work that he desires to in his bill. What we will not get to, nor are we expected to at this point, is a detailed how-to. We are providing information to help explain what this group feels is the best infrastructure to move a wellness model forward. The details won't be there. And I say that specifically around the equity piece. Someone asked me, when are we going to have the equity conversation? And I should have said, we should have it every time, and we should have it every time. But I also don't want to minimize the fact that whether we talk about it at 5 minutes at each meeting, or we have a future session, which we will, into the next year on that is not enough, right? I would offer we need an equity subcommittee if this work goes forward that is there the whole time, and it helps drive the discussion from the voices of people with whom we want to make sure are included. So we are not going to solve that, but to me, this group is to say, what are the pieces that need to be in place so that as this moves forward, when this moves forward, it can be implemented with the right information and the right voices at the table to do it. And we're not going to, so I just want to sort of level set expectations that we are not going to come up with a finished plan that's going to be implemented, right? We want the infrastructure, we want the direction, we want important pieces to be heard, and we want to be able to say, as this goes forward, however it goes forward, we're going to need a lot more discussion about the details of whatever this is. So I just wanted to level set with that. I know, you know, there's some frustration that we all at the government move slowly, and we do. But as you'll hear, I think from the Department of Health today, we have a lot of little rules and things that we have to follow. So wanted to just to kind of frame with that and level set that. We're hoping to have at least another couple meetings next after the new year. And the legislative session starts January 9th. I know Senator Solomon mentioned he was at a conference in Lisbon in the last week, which made him quite excited about. It was a European Drug and Alcohol conference, a lot of prevention focus, a lot of recovery focus. So I'll be interested and curious to hear what he has to share from that meeting. But really, we are helping to inform what he wants to do with his legislation. And again, whether or not the whims of the direction of the legislature always remains to be seen. We're still waiting for the governor's budget. Whether or not this work that we're doing now moves forward in this session, this is clearly an interest of a lot of folks. And there is an interest in moving this forward. And I will also say the legislature will be getting recommendations from other committees that they asked to be set up over this past year on what to do about decriminalization of drugs, returning that back, or personal possession mounts back to a felony, keeping it a misdemeanor, what that looks like. And so this is a confluence of a lot of discussions related to drug policy. So I just want to sort of say, we're not done. This is a beginning of a long-term discussion, depending on how we're directed to move forward. You're the right people to have at the table. So just want to kind of level set that. I babbled enough. I'm going to now turn it over to Lacey Fehrenbach and Christy Spice. They're going to sort of go through from the Department of Health's perspective, responses to the bill as it was written, as that is what we were asked to do. And we'll have a discussion about how we move forward or how we might do that. And Mike is going to Mike's going to help lead that discussion. Yeah, Emma, just a heads up, I think the committee, actually it's called the CIRSAC committee. I'll find a link, but they presented to the legislature yesterday their main recommendations from that year's group. So I'm going to turn it over to Lacey or Christine. I'm not sure who's going to start, but I will stop.
I'll start. Thank you, Dr. Fotinos. Good morning, everyone. I hope wherever you are in the state of Washington, you're warm and safe. And if you have to travel, you will be safe on the roads. There's lots of icy, slick roads out there and lots of school delays, including my own kids. So hopefully you don't see a 6-year-old running across in the background while we're giving this presentation. And if you do, hopefully it brings you a little joy in your life. We are going to walk through our authorizing environment with respect to how we license and regulate healthcare professionals. That is one of our tasks outlined in the proviso, and I have 2 presenters with me, Christy Spice, who's the Deputy Assistant Secretary for Health Systems Quality Assurance, and Marley O'Neill, who is the Executive Director for the Pharmacy Commission. And we are going to take you through. I'm going to start broadly with the agency's mission, vision, and transformational plan, very brief, give you an opportunity to learn more offline if you'd like to. And then we're going to walk through some fairly technical information and then move into discussion. As Dr. Fotinos noted, this really is framed around the legislation as it was drafted previously. So we don't necessarily speak to some of the ideas that have come up with this work group in our meetings over the past several months. So I want to start with the Department of Health's vision, which is equity and optimal health for all. And this statement about health, which is part of our transformational plan released following earlier this year in the summer, as we began to transition to the end of the state of emergency in Washington state for the COVID-19 pandemic, recognizing not just with respect to responding to emergencies, crises, and infectious diseases, the pandemic really changed how we look at health, how we approach health, and gave us an opportunity to do a pretty deep look at our portfolio, how we serve the people of Washington, and what we learned and how we can be better as a state, as an agency, and really importantly in promoting health for everyone in our state. Next slide, please. Our transformational plan has these 5 domains that you can see up here, and this work around psilocybin really crosses 2 of those most significantly: the health and wellness domain or strategic priority, which really focuses on total whole human health, whole family health, whole community health, and policy systems, environmental changes that help people thrive no matter where they live, work, play, worship, recreate, etc. And then the health systems and workforce transformation domain, which really ensures that we have both the public health and healthcare workforce, labor, people, and infrastructure, things like IT, hospital bed capacity, et cetera, to meet future needs of Washington state. And that reinforces some of those goals in the health and wellness and really helps people be well and then access the right level of care when they need it. Next slide. So we're going to start going through. If you want to do a deep dive on our transformational plan, you can take a scan of that QR code and it will take you to the full narrative document. And I'm also happy to answer questions when we get to the question answer section. And I am now going to turn it over to Christy Spice, Deputy Assistant Secretary for Health Systems Quality Assurance.
Thanks, Lacey. We will make these slides available. So if you didn't get a chance to scan that QR code and you want to, you'll have an opportunity later. So my task next is to really help you understand the existing regulatory framework for healthcare in Washington and the department's role within that. And this is definitely not an attempt to bore you to tears about regulatory work. We will try not to do that. The reason that we really think it's important to share some information about this framework is that it really influences how we think about the bill and our ability to implement it and our timeframes around implementation. So in Washington, the legislature has established a process in law for evaluating whether a health profession should be regulated. It's not a requirement for the legislature, but they do have the option to request that the department do what's called a sunrise review. So they give us a draft bill that would regulate a new profession and ask us to look at it relative to the criteria on the screen here, and then to make recommendations. And the core concept here is that regulation should occur when there's a risk to the public of unregulated practice. So again, that's just that overarching framework for when healthcare providers should be regulated. Once the legislature does decide to regulate a profession or a facility, it passes what's called a Practice Act. And for professions that will then show up in Title 18. So the legislature's role in that would be to establish the profession's scope of practice that really broadly defines what the profession can do. The legislature also sets broad requirements for licensure, and then importantly defines who the regulatory authority is. And when I say regulatory authority, it's who's got authority to set rules for a profession or facility and take disciplinary or enforcement action when they're violated. And in Washington, this work is really either done by the department or by a profession-specific board or commission. So for those regulatory authorities, the role we have is to set additional, more specific licensure requirements and rules. For professions, this may look like education and training requirements, testing, supervised experience, that kind of thing. For healthcare facilities, that will be health and safety standards, standards around the physical environment, and things like having policies and procedures in place that provide a base conditions for safety. In Washington, the Secretary of Health at DOH is the regulatory authority for 47 professions. There are 85, for frame of reference, 85 regulated professions in Washington for healthcare. Secretary has authority for 47, and again, boards or commissions have authority for the remainder of them. And I've just given a few examples here of the professions that would fall under either the secretary or boards and commissions. For facilities, for healthcare facilities, DOH has authority for almost all healthcare facilities. The one exception would be pharmacies, that's under the regulation of the Pharmacy Quality Assurance Commission. And the other exception is a few types of long-term care facilities like nursing homes that are regulated by the Department of Social and Health Services. So the work of regulation, these are really just the basic elements that we do in the department. So again, we are establishing those more detailed licensing requirements in rule. We're issuing credentials for providers that meet the requirements for licensure. We do routine inspections of healthcare facilities to assure that they are complying with law. We take complaints from the public about both individual healthcare professionals as well as healthcare facilities and go ahead and investigate those. And if there's, we find non-compliance, then we are doing enforcement actions, against a provider's license to assure that the public is safe. And then the final piece, so for all of those boards and commissions that exist, they are staffed by practicing healthcare practitioners who don't have a lot of time to give, and we're very thankful for what they do. But we are providing then all the staffing support to really allow them to operate and function. And of course, within the circle there are some of the core values that we operate from as we do this work. Lacey mentioned equity, innovation, and community engagement, and those are absolutely key. We're also keeping a keen eye on patient safety, as well as balancing that with assuring there's access to healthcare in our state. So I'm going to go back out and talk now about state law and the framework in state law for healthcare regulation in Washington. All healthcare professionals, so this is not facilities, but individual healthcare professionals, all 85 of them are regulated under Title 18, and they are subject to a common set of laws that exist in addition and to and on top of their profession-specific practice act. These are laws that touch on things such as application process for licensure, professional standards of conduct, disciplinary procedures, whistleblower protection, and fees for licensure. And I'll talk about each of these in a little more depth. So the state's Uniform Disciplinary Act provides a common set of professional standards for practice. It covers all healthcare professions that are regulated under Title 18, whether the authority is the Department of Health or a board or commission. It also provides standardized procedures for how we license and discipline all healthcare professionals in Washington. And the intent section in this chapter articulates the legislature's vision, and that is that the Uniform Disciplinary Act should cover all health and health-related professions that are newly regulated by the state. The authority that the Uniform Disciplinary Act grants to DOH boards and commissions ranges from the authority to grant or deny license applications. We can place restrictions on licenses. We certainly then are given the authority to investigate complaints and go through the administrative law process, whether that's holding a hearing, issuing subpoenas, and so forth. We've got authority to take action for non-compliance, whether that's sanctions, fines, including suspending or revoking a license. And we've got specific authority in circumstances where there's an immediate threat to public health and safety. We can do what's called a summary suspension or restriction. The Uniform Disciplinary Act, as I mentioned, also sets a framework for how we review applications for licensees. We're looking at two key questions here, in addition to the questions of, does the applicant meet all of the requirements for that license? We're also looking at whether the applicant has a criminal history that would pose risk to patients. So we have authority to do both state background checks through the State Patrol as well as FBI background checks. I want to be clear, DOH has no disqualifying crimes list. We evaluate every single applicant on a case-by-case basis, and we're looking at the very specific criminal history and how it relates to the very specific type of license the person's applying for. And the reality is that under 1% of applicants end up getting denied because of criminal history. It's not a common thing. We are also considering the question of whether the applicant can practice with reasonable skill and safety. And so here we're asking the applicant to self-report health conditions, right? And we're not interested if the applicant wears glasses. That's not the point. We're looking for serious health conditions that, again, could pose risk to patients, severe cognitive dysfunction or other issues. And one of them would be substance misuse. When we have an applicant that has self-reported substance misuse, sometimes we will have an option to offer that person to voluntarily go into a substance use monitoring program in lieu of denying them the license. So I also had mentioned this Uniform Disciplinary Act sets common standards that all health professions have to follow in terms of conduct. Although the way that the law is written, it's actually really a list of things that are considered misconduct. I won't go through each of these in detail, but I wanted you to have them available. These range from, violating any state or federal law that pertains to the profession, certainly engaging in any corruption or fraud, providing false information on an application, providing care that results in injury or an unreasonable risk of harm to patients, practicing beyond the scope of practice that the legislature has set for the profession. And then just a few more. And this is where, we get into some of the restrictions and misconduct around drug use. So possessing, using, or prescribing drugs other than for a legitimate purpose, violating any drug law, and any current misuse of alcohol, controlled substances, or legend drugs. And then finally, the Uniform Disciplinary Act defines abusing or engaging in sexual contact with a patient or client as a violation. And I will say that all of the professions have actually gone further than what's in the Uniform Disciplinary Act and created additional definitions for what is sexual misconduct that are far more inclusive and go as far as saying simply asking a client or patient out on a date is considered sexual misconduct because of the power differential between providers and their clients or patients. So moving away now
Christy,
from the, yeah, please.
Can I just ask a question on that last slide? As it relates to the work we're doing in this committee, would the third bullet require the Uniform Disciplinary Act to be changed as one thing that would need to be different to actually implement something like this, or is that?
Yeah, I will speak to that a little bit later, Charissa. I do think I'll just say at this point, this is a challenge that the regulatory authorities will face, just as they are in Oregon, with sorting through, again, what we do when something is still a federal crime.
Okay, thank you.
Even if it's deregulated in the state. And I also, please jump in if there are questions as I'm going. I won't necessarily see hands, but I'm happy to pause and take them as we go. Whistleblower protections. The department's authorizing statutes have a provision that protects confidentiality of whistleblowers who complain to the department about healthcare professionals or facilities. It also provides those folks the right to sue and take civil action if they're subjected to retaliatory action as a result of having made a complaint. So if a person believes their healthcare provider is retaliating against them and treating them differently because they complain, they have a right to sue. Of course, people who are employees and are then subject to retaliatory action for complaining against their employer have a whole additional set of protections through the Human Rights Commission.
Christy, I have a question for you about this. This is
Super.
Hi. So yeah, for the whistleblower protection, is there anything within this kind of bundle of regulations that support the process for the person complaining? Like after they complain, right? And then what happens? Is there any kind of, I'm thinking from a restorative justice lens, is there anything like currently implemented in this process?
Yeah, thanks, Emma, for that question. And I will definitely, Marley, if you want to speak on this as well, I welcome that. I will say that, there's what we do as regulators under administrative law is really fundamentally different than the criminal justice system. The actions we're taking are not aimed at making the harmed party whole. Our authority and the framework from which we operate is about protecting the public at large. So, an action against a licensee might be taking away their license, which prevents them from practicing. And the outcome there is, again, preventing additional harm to other patients, but it isn't necessarily restorative justice for the person who is harmed. Marley, do you have any other thoughts you want to share on that?
Nope, I think you covered it. That's accurate.
Okay, all right. Thanks for the question. I'll shift now to talking briefly about the regulatory framework for fees for healthcare regulation. The department has a state law that requires that the regulation of health professions and facilities is supported by the fees that are paid by licensees. And that law means that fees paid by one profession may not be applied to licensing or regulating any other profession. So we really have an obligation here to be setting fees in a way that enables us to recover all of our costs, except in a very limited number of cases, the legislature has chosen to provide funding to offset licensing costs. And those have been midwives and emergency medical professionals. So we're talking 2 out of about 85. So it's not a common practice, but it certainly would be a legislative option But absent the legislature acting in that regard, again, we must set fees to recover the full cost of regulation. And so what does that mean when I talk about cost recovery? We must, with fees, offset the full cost of all that we do around rulemaking and licensure, complaint investigation, discipline, support for boards and commissions, all those things I talked about earlier on an earlier slide. In addition to that, we also have a responsibility to maintain a sufficient financial reserve to cover fluctuations in expenditures. This is an expectation of the Office of Financial Management for the state, and something that typically represents 2 to 3 months of operating expenditures. So the fees are not just the precise cost today, but also, again, have to have a fund reserve built in. The reason for that is that occasionally we have very expensive disciplinary cases, and we cannot have the fund balance for any of the professions or facilities going into negative territory. All right, with that, I will shift to Marley O'Neill to talk about the role of the Pharmacy Commission in drug regulation.
Cody has a question.
Absolutely.
Hi, excellent. So I'm just curious, has there been any estimation for for what these costs might be in terms of psilocybin service providers?
We did a fiscal note on the bill, so I would definitely point you to look at that. It's on the legislature's website, and there was a lot that for us was indeterminate at this stage, and will just require, this is such novel work for us, that we will have, and I think we don't have a good sense of the number of potential licensees coming in. So for those reasons, we do not today have a good estimate for what fees would look like.
Okay, great, thanks.
Yeah, thank you.
Chris, if I can jump in. Oh, sorry. Mike Bonetto here. So that's Cody, we may want to follow up with Oregon on that though, because I know they had some very similar problems of Chris, to your point, just the indeterminate. I mean, just trying to get their arms around it as they're moving forward, obviously launching in 2023. We may want to circle back and just understand a little bit more of their funding model.
Yeah. So with Oregon, I believe it's a $10,000 license for a service center and a $5,000 license for a service provider. I find that very cost prohibitive for many of these facilities, many of these service providers and facilitators. So I just I can share some of the documents about that a little later, but it leaves me very concerned for for accessibility for many of these people going forward with this.
Mm-hmm. Sunil?
I'm muting here. Good morning, it's Sunil Agarwal, Ms. Spice. I just had a question. You mentioned earlier about the issue at the federal law and what Oregon has done around the issues around drug misuse definitions and what's legitimate in the state. I also wanted to see if you looked at the Colorado proclamation that the governor of Colorado put out maybe earlier this year that sort of protected all licensed professionals in the state for related to, of course, they didn't have a psilocybin services law yet. That passed, or it's a broader law that passed earlier this month or last month, but that was related to cannabis. And the cannabis issue was a big one in Colorado earlier on, about 10 years ago, when the Colorado Board of Licensing did not allow physicians to become licensed cannabis patients. They would revoke their license as a result of that. There was specific policy, but now that the state governor has this proclamation, it's very clear that any licensed professional in the state, any type of license, attorney, doctor, therapist, probably accountant, there's no civil mark against you if you're related doing anything related to legal cannabis in the state. So I just wondered if you looked at that option, because as a licensed professional myself here in Washington as a physician, I've gotten newsletters from the Department of Health saying things like, oh, maybe you shouldn't really be watch it at a party if you even though cannabis is legal in the state, it may not be right for you, and we don't really have, it's under the physician health program, the monitoring program that you mentioned earlier, and there's been a lot of issues with the sort of overreach of those programs in multiple states. So I'm concerned about that and wondering if you had any thoughts.
Thanks for the question. We have broad awareness of that executive order, but it's not something that we have looked at in depth. And I think, it's what you're speaking to is going to be a very real challenge. And ultimately, there's probably legislative action that could be taken. Whether or not the governor would take executive action or what his authority would be is not something that we can comment on at this time.
Okay, thank you.
Yeah, thank you. And Cody, I just wanted to loop back for a moment on your concern about fees in Oregon and just say that I think we really appreciate the conundrum that this creates. This statutory framework around, again, fees for healthcare providers is not one where I think an equity framework is built in at this juncture. We have home care aides that are one of the lowest paid healthcare professions in the state. They make less money than fast food workers, and we must charge fees to recover the full cost of licensing them. So we're, I think, very aware of and sympathetic to the challenge, and yet this is again, the regulatory and legal framework under which we have to operate at this point. Okay, Marley, over to you.
Thank you, Christy. So I want to just spend a little bit of time talking about the regulatory framework that the Pharmacy Quality Assurance Commission operates under. So the commission regulates the practice of pharmacy professionals and pharmacy entities in Washington state, and this includes the dispensing, distribution, wholesaling, and manufacturing of all controlled and non-controlled substances, which includes psilocybin. So the commission regulates what might immediately come to mind, such as pharmacies, pharmacists, pharmacy technicians, and then, as I just mentioned, wholesalers, manufacturers. But this also includes what are perhaps some lesser known entity types, such as researchers, analytical labs, and dog handlers. So just going back to my earlier statement that the commission's regulatory authority involves both controlled and non-controlled substances, Chapter 6950 of the RCW contains a list of controlled substances that the legislature has set. And as you know, psilocybin is listed there as a Schedule I drug. The commission also has rules. Those can be found in Chapter 246945 WAC, and they also have the authority to add substances to the various schedules. And then, of course, the DEA at the federal level also regulates controlled substances, and those schedules can be found in 21 CFR Section 1308. So the regulatory framework that the commission's licensees work within requires that both personnel and entities follow both federal laws and rules and Washington state laws and rules. This is what Christy mentioned previously. So when, say, dispensing or manufacturing controlled substances, one has to have both a DEA registration and a license from the commission. And you can go ahead and go to the next slide. Thank you. Just to speak a little bit about the framework specific to manufacturing. So I won't read the entire definition of manufacturing, but it does mean the production, preparation, propagation, compounding, or processing of a drug or other substance. And within the commission's rules, the commission requires that manufacturers comply with current good manufacturing practices, or CGMP, which can be found in Title I of the Code of Federal Regulations. And CGMP, these are regulations for drugs, and they contain the minimum requirements for the methods, facilities, and controls that are used in manufacturing, processing, and packaging of a drug product. So regulations around training and cleanliness and how one might go about building and structuring a facility. And so really the intent here, right, is to ensure that the products that are being given to the ultimate user and the patients are safe and effective for what they're intended to do. So I hope that this provides just a little bit of insight into the sort of highly complex regulatory framework, as Christy mentioned, that the Commission operates within, that we're both following state laws and rules and federal laws and rules, and it can get quite complex.
Thanks, Marley.
Happy to answer any questions. Yep.
Pause there and see if there's any. Okay. Then we're going to shift gears and talk about the department's responsibilities under Senate Bill 5660. And I think what's core in terms of interest for this group, as well as the task of the work group, which is assessing DOH's ability to implement. So the bill gave DOH a very broad set of responsibilities to carry out. And again, you all know this as well as we do, so we won't belabor this, but just to briefly go over them, we would be establishing a psilocybin advisory board with over 20 appointed members. The board would advise DOH on a broad number of topics. We would be conducting rulemaking in order to license and regulate a lot of different entities, psilocybin manufacturers, service centers, and facilitators, employees of manufacturers and service centers, and laboratories that test psilocybin products. We would, in addition to doing rulemaking on the social opportunity program for the psilocybin industry to aid people from distressed areas through reduction in fees, we would be looking at how we identify distressed communities and so forth. We would be developing and maintaining a system for tracking transfer of psilocybin products or using the Liquor and Control Board's cannabis system. We would publish research and information on safety and efficacy of psilocybin, and then finally develop a hotline or website to answer questions from the public about licensed psilocybin premises. So do we have expertise and capacity to implement? I think, the first thing we really want to communicate is we don't have expertise in psilocybin. This would be brand new for us. Standing up these services would be truly novel work. And it's novel not just because psilocybin as a topic would be novel for us. There's elements of the bill that also are just brand new. Again, having a social opportunity program for fees, as Marley mentioned, regulating a cultivated product. Again, a new thing that we just haven't done before. The proposed regulatory structure in the bill is highly, highly complex. It has a proposed regulatory structure with similarities to existing laws for other health professionals. So again, similar to something like the Uniform Disciplinary Act, but it's distinct. And therefore, it's going to require extensive rulemaking, procedure development, as well as IT system changes for us. So the core question, can we implement this bill? Absolutely, yes. We absolutely can if we're appropriately resourced and we have more time. And so what is that time frame to implement? We believe it will take no less than 2 years and more likely up to 3 to be able to do this work. And I know, and I just want to acknowledge right up front, I absolutely appreciate how frustrating that is. Charissa talked earlier about government moving slow, and while we don't intend it to move slow, and we move things forward with implementing all bills as quickly as we possibly can, we do want to help give you a window into the work that's involved and why that kind of a time frame is required. So for this bill, we would be starting with needing to hire about 30 people. The department, just like all employers, are subject to whatever the current labor market conditions are. I will say currently with the low unemployment rate, we are struggling to fill positions like I'm sure you're all familiar with as well. So that takes time. We also will need to stand up this advisory board, get people appointed to it, get it meeting and functioning, and really just going through that establishment phase so that it can begin to advise the department on this vast array of rules that we will have to develop. Rulemaking is always a time-intensive process, just in terms of what the Administrative Procedure Act requires, but also more importantly, doing it in a way where we are truly engaging in an equitable manner and in a broad manner to assure that all people in the community who have an interest in the rules have an opportunity to participate. So those are rules that will take at least 18 months to promulgate. We will also be working to stand up the social opportunity program. And so for that, it's not just the rulemaking work, but we have to figure out a method for identifying distressed communities and then doing some, I think, very robust fiscal analysis about the tiered fee concept. So we assure, again, we're cost recovering and we have the revenue to actually operate the programs. And then finally, the psilocybin tracking system has to be acquired and implemented. And for anyone who's worked or had to acquire an IT system in your business or organization, those take time. I will say within the state government structure, those take a lot of time. There's a lot of requirements and oversight from the State Office of Information, the state, Chief Information Officer, and other groups within state government that have oversight and process that, again, makes it a very time-intensive thing. So,
Christy,
yeah, please.
I'm sorry, just to jump in. This is Dr. Roll. I had a quick question about the acquisition of that system.
Yes, yes.
Acquisition suggests you think there's something that is adequate out there instead of development of a system which might meet our specific needs. Does that reflect a preconception?
It is not intended to. So I think the way the bill is constructed, it was, either get a system to do this work or partner with Liquor and Control Board. Whether, so if we don't do that latter piece and we are acquiring a new system that is, it's going out, doing, a request for proposals, a contracting process, getting bids, bringing on a firm to either build from scratch or what is far more common now in state government is to purchase a product that can then be configured to meet specific requirements that we would have. But that's a multi-year process.
I appreciate that. Thank you. I think there's some difference of opinion on what the current ones do and don't do, but I'm very appreciative of your efforts. Thank you for the answer.
Yeah, absolutely. And we did hear some of the concerns about the appropriateness of LCB's cannabis system for this purpose.
Jim, did you want to weigh in? I saw your hand.
I was just going to add that regardless of whether a system ended up being an off-the-shelf system was procured or a system was developed, a tremendous amount of the work is necessary to define the requirements of the system. What do you really need? And until that happens, then that question can't be answered, whether there's a system available or whether it needs to be developed. But the procurement process and the length of the process really doesn't change all that much. It's still a lengthy process, even if a system needs to be developed.
Sure, I appreciate that. Thank you very much, Jim.
Yeah, and I do too. I appreciate that, Jim. Yeah, I will say IT is one of the longer processes for us of anything. So don't want to underestimate that piece. All right. We do have some additional considerations around the social opportunity program. First, I think this is for us a super intriguing concept.
Hey, Christy. There's a question I'm thinking on the last topic.
Oh,
so I just
thanks,
wanted to jump
Lacey.
in before you moved in. It's from Cody.
Hi, Cody.
Hi, yeah. So, especially with regard to, psilocybin, I mean, unlike liquor or cannabis, this isn't being distributed to the it's not a readily available consumer product. You don't go to a dispensary, you don't go to a liquor store, and you buy it and consume it. This is under the guidance of a professional, where, you know, as 5660 lays out, there is, you know, specific rules for, you know, acquiring and procuring and growing these substances. So I just kind of question the, you know, the need for a similar system under like the LCB to be required here for psilocybin services. And I just kind of want to bring that point to everyone's attention.
Thanks, Cody.
Can I address that real quick?
Sure.
So my impression is the requirement to evaluate LCB's system was from a kind of an uninformed, hey, they have a system, see if their system will work, rather than an expectation that our system would work. And we've had a fair amount of discussion here, and I don't believe that it would work. I think the process that we use, the technical aspects may be able to be applied to a system for psilocybin, but it would still be a different system that's developed for the specific needs of this program.
Thanks, Jim. Any other questions or comments on that piece? All right.
Well, I'm just kind of curious, like, what is the normal process for, you know, other types of drugs? I mean, if we're going to be, you know, considering this as a drug, and, you know, with all the, you know, CGMP manufacturing, you know, and not regulating it like a food product or something, then I just feel like that should be, there's probably a different approach to that.
Thanks. And Marley, I'll certainly again invite you to speak here also. We don't have similar requirements for tracking transfer of other drugs. That's not something we've got requirements to do or IT systems for, unless Marley disabuses me of that notion.
I mean, there are requirements within the pharmacy laws and rules, both on the state side and federal, that entities, you know, track, you know, what's coming and going and things like that. But in terms of a broader statewide system or something like that, like, we don't have that.
Yeah, thanks, Marley. So again, the requirement may be on licensees, in that case, pharmacies, to do tracking. But what this bill would do is call on the department to stand up a tracking system.
But it would also, as someone who did field work for a number of years as a prescriber, I would get medications from the pharmacy, but I had to track the NDC number. I had to track and link that to the product that I handed to that person. And this was not even controlled substances. And I had to record that by the person so that if there were a recall, I could provide that information. So there is, wherever it comes from, there will be some sort of tracking that will be required, whether it's on the facilitator side that they'll have to submit, or the pharma. I mean, so, and that doesn't exist, that sort of piece.
And this is Sunil, if I can just comment, Dr. Fotinos, I think I also do that tracking in my practice. Getting drugs, it's there's no special computer system. It's just recording it down in the, you know, the chart. And so the drugs that you're talking about are not controlled. And I'm wondering if the representative from the Pharmacy Quality Commission could comment on possibly working on lowering the schedule of psilocybin in the Washington law. Previous times, the committee, the Quality Commission, has taken on rescheduling of cannabis. They did that in Oregon as well. And it wasn't really petition initiated, it was initiated by the board itself, which sort of simplifies, I think, would simplify some of the concerns that if you know, regarding how much tracking would be required. So we, you know, yeah, it can be included in the legislation. Cody's commenting. I think that makes sense. I have a pending case before the Ninth Circuit Court on our rescheduling psilocybin at the federal level that was denied, but we're getting a lot of amicus interest in that. So I wanted to encourage just to think about that too. That's something that could be done. And there's lots of scientific opinion that supports the, you know, a lower scheduling. So I'm happy to share some of that with you if you're interested, or our petition that we originally wrote. Thank you so much. Any thoughts from the Pharmacy Commission representative about that?
Sorry. Well, currently psilocybin is a Schedule I drug under the RCW, the Revised Code of Washington. That's what the legislature put into place. So I do think it would require the legislature to take some action to deschedule that. Does that make sense?
Well, I don't think that's because in Oregon, it depends on, I think there's a authority also, it's not just vested in the legislative branch to initiate those processes. I'd have to look at the lawyers on the call, maybe know more, but I thought there was a way that it could be done by the commission itself.
Well, I will have to do a little bit more looking into that and work with Christy and Lacey. Yeah, so I appreciate that comment as an option.
Yeah, and I will just say, you know, the state laws around healthcare regulation are, yeah, there's similarities state to state, but there's also a lot that's different. So what Oregon may have had the authority to do may or may not be something that we can do here. So, but very much appreciate the comment. Okay, I think we've talked about the system for tracking transfer product. Again, we are bringing this forward as a consideration because that is what the bill required. So the bill required us to set up a system. Definitely hear all the comments about, gosh, is that really necessary? But we're just responding to, again, the department's ability and time frame to implement what was in the bill. I'll just go back briefly and say again, this social opportunity program is something we think is really interesting and really worthwhile to be looking at. But the piece that I think is important for this work group to consider is that the action of taking some licensees from distressed communities and offering them lower fees will have the effect of meaning higher fees paid by licensees from non-distressed communities. In other words, the department is still in this place, right, where we have to recover the full cost of the regulatory program. That's a zero-sum game for us. And so again, if we have a tiered structure for fees, it will mean higher fees for those that are from non-distressed communities. And perhaps that's fine. We're not trying to suggest we have an opinion on that one way or the other. That's just one of our, again, statutory considerations that we have to follow. And with that, just a couple other quick thoughts. The Psilocybin Advisory Board, the department in the bill is vested with the authority for doing the rulemaking and for enforcing the requirements for the variety of entities regulated. The advisory board as written is advisory to the department, even though it's got a lot of similar trappings as a class 1 board in terms of having, you know, the statute actually prescribe appointed members and how the board will function and vote and make decisions and so forth. Again, what's important that we wanted to make sure we were sharing is that the department will be obligated to follow the Administrative Procedures Act when we do rulemaking. And that means we have to do really broad public engagement and seek a wide array of perspectives from anybody who would be interested in the rules. And so that will extend beyond the advisory board. We won't have an opportunity to only work with the advisory board on rules. And then finally, Christy, and this is, please.
Christy, could I just jump in and ask a clarifying question around that I think I know the answer to, but I just want to be really clear. Yeah. So the advisory board obviously has advisory capacity, and then the DOH makes the rules. Are you saying that the space between those is where things like other organizations and lobbying can get in to impact the final rules?
Exactly, Emma. So the advisory board can vote on and make recommendations to the department, and the department would take those into consideration as we do rulemaking. And we will also have to go out and seek input from other interested parties and take that into consideration as well.
Yeah, that makes a lot of sense. Is that something that is tracked and made publicly available?
Yes.
Okay, great.
Yeah. Okay, the last piece on here is really, you know, what we spoke about earlier. I won't belabor it, but we do, you know, the regulatory authorities, department, boards, commissions, we all have a duty to consider disciplinary action when we become aware of a licensee who's engaged in illegal activity. And what that means is, as long as psilocybin is illegal federally, this is going to be a bit of a bind for the regulatory authorities. We are not here today to speculate on how the boards and commissions will handle this in the future. You know, we're also not here to say that's going to mean they're absolutely going to continue to, discipline to the furthest extent of psilocybin. I don't know how this would play out at this juncture, but we just wanted to reflect, regardless of what happens with state law around the scheduling of psilocybin, as long as it is federally illegal, it is, from a regulatory standpoint and the duties that we have, it's a little bit of a bind. And with that, we simply wanted to leave one recommendation. And that is, if we really want to think about how we might speed up the process of implementing this bill, one of the key things I think that could be done would be to consider using some of the existing regulatory framework for healthcare in Washington, such as the Uniform Disciplinary Act. If we do that, we can depend upon rules we already have in place for a lot of these things, rather than having to go through additional rulemaking to create them. So we see that as probably the greatest opportunity to facilitate timing of implementation. And there were certainly other pieces we spoke about earlier. There are a lot of other detailed issues in the bill that we're happy to discuss. If there's interest, that this would be kind of our most overarching recommendation. And with that, we would very much love to hear what other questions you have. And here's contact information for each of us.
Christy, Marley, thank you. I'm going to turn it over to I just wanted to thank you for that presentation and the thoughtfulness that went into it. I think you painted a really good picture of sort of what the asks were to the Department of Health and what within your current structure you would or would not be able to do with the bill as currently written. So I want to thank you for your thoughtfulness as you put this forward. And Mike, it's all you.
Charissa, thanks. Yeah, Lacey, Christy, Marley, I thank you guys. I thought you guys did an outstanding job of putting this together. I mean, we've been talking about kind of a lot of big picture stuff, but this kind of brings it into focus in terms of kind of that reality check of what needs to happen, what needs to change. So really appreciate that. I've got a few questions, but I definitely want to make sure we get to others. So work group members, we're at 10 o'clock. We've got 30 minutes to kind of go through some group discussions. I see some stuff already populating in the chat. I see some hands raised. So let's start kind of going through this as quickly as we can. Cody, I just saw you posted something in the chat. Do you want to comment on that?
Yeah, I just want to say, I understand, like, what a lot of what you're saying here is, this is like just currently the way the law is constructed, and it's currently how we are constrained. But, at the same time, I think this just speaks to the need for a very thoughtful law to be constructed to address some of these concerns and ensure this is the best program, the best situation that we can create for psilocybin, service providers and also the institutions that are engaging in the licensing and certification of this.
Got it. Thanks, Cody. Sunil, I saw your hand raised.
Yes, thank you. I was just wanting to invite the DOH representative to this issue on federal scheduling of psilocybin. Sounds like could be a big issue, but luckily you do have an active case in the Ninth Circuit, which Washington is part of, called the Ames 3 case, which it is specifically regarding the scheduling of psilocybin. And we've previously had the Washington Attorney General's office participate in that legislation as a fellow arguer, on behalf of our case. This is the Ames case that I've talked about here before. So now we're challenging a denial of rescheduling psilocybin petition. And I think there's a strong amicus basis, and I'd love to have the Department of Health weigh in on the need for that, for the court to guide the DEA appropriately. And that's just an action that they could proactively take now, without any legislation, just based on the same way that the Attorney General's office did it. So I just wanted to add that piece because I'm here and it's happening, so it's relevant.
Christy, others, you guys have comments on that?
Thanks, Sunil, and we will get connected with leaders in the governor's office here to learn more and see if that's something we would consider.
Thanks, guys. So one follow-up I had was just regarding the budgeting around this. Christy, you talked about kind of the first round of just kind of the indeterminate amount of trying to determine fees. But you also mentioned kind of this time around kind of building out with 30 FTEs as a starting point. So, as I think about legislation potentially moving forward in 2023, there's going to be some refinement, and that 30 FTE is going to be obviously included, I would imagine, to some regard. Do you see any other aspects of fees, structure, or anything else when you talk about the tiering or anything like that that could potentially be included in that to give it, a little bit more, viability, or even through that equity lens?
Let me see if make sure I'm understanding your question. So is there anything that we think could be done to keep fees as low as possible? Is that a reasonable paraphrase?
A budgetary request. So you're going to have your operational expenses, right, through your FTEs that are going to be kind of line item, but then anything else in terms of that fee structure that would be kind of coming out of the gates, to Cody's point, that you're not going to have $5,000 or $10,000 fees associated with this.
Right. Okay. Thank you. So the way our fiscal note was structured last legislative session on the bill is that we request general fund state to cover the cost of standing up the regulatory work. So we can't start charging fees until we have regulatory programs in place. And so that is a normal practice for us. We will request general fund to do what is needed to get everything in place. And then that fund source will shift, unless the legislature decides differently, would shift to the fees.
And Christy, that's really helpful. And last time, did you have, I don't have it in front of me, did you have a 30 FTE tag on that last time?
Yes. You
did have it last time. Okay, got it. Thanks. Emma, so you had your hand raised.
Thanks, Mike. Christy, could you speak a little bit more to, it was one of the last things you said about, as long as psilocybin is Schedule I federally, that licensed healthcare providers in the state might have an issue with using it. I know one of the recommendations that we've put forward to Senator Solomon is around DOH, maybe saying some kind of protective statement. I know it can't ever be 100%, but that DOH won't take away people's licenses if, we decide to work with this. Could you just say a little bit more about that? I want to make sure that I really understand there. I'm a licensed therapist, so it really matters to me.
Yeah, definitely understand. And again, Marley, please weigh in if you have more to offer on this. Marley, of course, is an executive director for an independent commission that has authority in this regard. She's also an attorney, and I'm not. So what I would say on that is certainly the legislature can make a change that would, to the Uniform Disciplinary Act that would remove that from being a risk. As the bill was currently structured, that's not something that was particularly addressed. So that then puts the regulatory authorities, and again, the department's got authority for some professions. Other professions or facilities would be under a board or commission that has, frankly, authority that is independent of the department. They would make their own decisions. So for instance, the Washington State Medical Commission, which licenses physicians in the state, would make its own determination about how they would handle a disciplinary case that came before them, where the allegations are that the licensee violated federal law around psilocybin. I don't know if that's helpful. Again, our intent was definitely not to come and say, DOH would be really trying to be draconian on this. I don't know where we would land or how we would approach that. We merely wanted to say, it's a bind. You know, it's a bit of a bind the way the laws currently are right now.
Yeah, that absolutely makes sense. And I know in Oregon, this is something that they're absolutely wrestling with right now, and that some of the work has been around, working with the commissions and the professional associations with the specific, practice groups, and having them publish statements that they are in support of this. Is that something that the DOH in Washington does do? I know you can't give me a straight yes or no, but might that be a potential route as well?
Boards and commissions and the department do publish what are called interpretive statements. That's where we formally say to the public, this is how we interpret the law and what we will do. But again, I think we are not at a point where we can really speculate to say what action would be taken. If the bill passes, that's something we'll be sorting through, as will the boards and commissions.
Yeah, understood. Thanks so much. It's really helpful.
Other questions? Chris, you had another one. Last time that we had a work group meeting, we had kind of a panel of some safety experts from around the country. One was Alex Cardenas, who spoke. And one of the things that he had mentioned was referring to kind of the tiering that you talked about. And there are kind of these national certification levels. And one example that he gave was for the National Association for Addiction Professionals, that they've got certain levels of, I'm just kind of looking here, a level 1, level 2, and kind of a master kind of addiction counselor. How does that then play into kind of a DOH oversight? Because I mean, his thinking was, gosh, we've got this at a national level. Couldn't we do this at a state level and actually then have a tiered structure kind of to correspond with that? Do you see any kind of correlation there?
Mike, thank you. I'm trying to remember back to what his comments were. When you say a tiered structure, do you mean tiered licenses?
Yeah. Right. So the tiered licenses that could also go to tiered fees as well. But yeah, his was more specific to the licensing.
Okay, thanks. Yes. So what I would say is that, again, the legislature establishes licenses. They establish professions. And, they will say there is, within the framework of, for instance, social work, there are a variety of different license types for social workers, but again, that's established. That's legislature's authority to establish that or not. They can certainly look to and draw upon national models and models in other states, and often do. But that, we don't have independent authority within the executive branch to set that up. That's a legislative responsibility.
Got it. Thanks. And Emma, yeah, I saw your note there as well. Right. I mean, that really was what he was been advocating for as well on the medical side. Other questions, since we've got some great knowledge here. Christy, anything else that you would talk about on the time frame? I know this is something that Oregon talked about, that they were a bit of a time crunch, right? And I think that was kind of a lessons learned. And you talked about really kind of that minimum of 2, potentially 3 years. With a passage, let's just say hypothetically, coming this session, that would mean kind of, you're talking 3 years out. So from 2023 to 2026. What are your thoughts there?
Yeah, thank you. I would characterize it as, yes, somewhere between, if it were to pass and the bill were to take effect in July 2023, then we're looking at somewhere between July 2025 and July 2026. I think the one piece which potentially really concerns me about extending beyond that would be the IT system for tracking psilocybin product. And I'm not saying it necessarily would, but as we spoke about earlier, there's a lot of work there around identifying requirements, gaining permission within the state enterprise for an IT project, doing the full procurement project, and then, developing or configuring a system and actually deploying it.
Got it. Thanks. Other thoughts, comments? Cody.
Yeah, so this is just a a very general question in terms of, I mean, you're talking about if this passes next year and what the future looks like. I do know there was going to be a preliminary report released to the legislature, and I'm just curious what the status of that is and where to find it when it will be released.
I can speak to that, Cody. So we actually, I think it's due today, we're not there. We were waiting for this meeting and what that report will be. And as soon as we submit it and we have a process we have to go through to submit legislative reports. As soon as we're given permission to release it, it's pretty much well developed already. We just need to add sort of today's meeting into it. And really what you'll see in it is you will not see all the detailed discussions. You'll see all the information that was shared through all of Duncan's interviews. It will be addressing the points that both DOH was required to as part of the proviso, as well as Healthcare Authority. And I will also, I believe, be adding sort of some recommendations for next steps, because clearly just from the conversation today, this is a very big body of work that we can start the discussion on. And that's what I see this preliminary report as, responsive to the proviso, and whatever path Washington decides to take, it's going to need a lot more discussion and a lot more work by a lot of people. And so our final report is due, I think, in June of next year. We'll be happy to share the draft, but just for expectation setting, it's largely going to be very focused on what we were required to do by law, and then reiterating a lot of the meetings that we've had, those topics, and any attachments that may come with them. So that's what you'll see when we release it.
And Charissa, I would also add on to that, a lot of the survey feedback from this work group will be included. So I want to make sure that's not going to be lost. So all of that, I mean, that has been, I think, really helpful to kind of make sure that we understand kind of the group's position. So yeah, a lot of that survey stuff that you've done over the last, many months will also be there. I saw a few more things in the chat. Anything else that folks want to highlight?
Oh, I see Paul put a comment that he didn't get a chance to talk to Duncan. So I don't know if Duncan's with us and that's something we can rectify, or I don't know.
Yeah, Paul, we could rectify that. I sent you a couple emails, but maybe I had the wrong info. So we must have just missed each other.
Yeah, my email is paulstamets@gmail.com. As you can imagine, I get a lot of emails, but I don't recall ever seeing one. So I would very much like to have my voice and thoughts considered. Thank you.
Yeah, absolutely. I'll send you an email after this.
Great. Thanks, Paul. Thanks, Duncan. Appreciate that. Anything else?
Interesting. U.S. Senate's looking at this. Interesting.
Charissa, you had mentioned earlier kind of just the plan for 2023. So, we initially set out to have 5 meetings. This is meeting number 4. So number 5, I think, is still a TBD, but after the first year, I think we're going to kind of circle back and make sure that we've got schedules aligned, we get as much participation as possible. But there still are some things that we want to be able to circle back on based on all of the feedback that we've had here today, as well as starting to form up that final report that I think, we want to make sure that there's some eyes on as well. And Charisse, I'm kind of looking to you. I think there's still maybe some decisions on its meeting 5, meeting 6. We want to make sure that your voices are heard before that report is finalized. So I think we're going to do our best to make sure that we can ensure to do that.
And yes, thank you, Mike. And we'll work with your team on how to make that. So I'm going to put a link in the chart. And Emma, this is in response. Let me know if it doesn't work. This it came out really ugly, but this is a link to the Blake webpage. And the Blake bill was the one that removed the felony citation, that's not the right word, but felony level charges for personal use, for possession of, for drugs of personal use, to a misdemeanor. And they were within that bill. There was a lot of requirements that a committee called the CSRSAT committee was tasked to respond to. And this link should take you to that page. Yes, Cody, it is, the next meeting will be, so what I am thinking, and this is a recommendation the group can weigh. I would see the 2 further meetings doing 2 things. One, as I mentioned, sort of not in any way pretending that we would address all the equity issues, but to have a focused conversation on what do we need to create so that is a deliberate conversation going forward from this point. And what are the considerations? What should that look like? What do we recommend for a minimum of how to assure that process is in place going forward? We don't have time to do it justice for any recommendations now. And so I think whatever happens and whatever path this goes, there needs to be very clear voicing as to that. And some of the folks on the committee that weren't able to join us today will be really important in that discussion. So I think that is one potential topic for the next. And the other, I think, is, you'll have had a chance by then to see sort of the summary of the discussions we've had. And I think I'm curious as to the group's thoughts. I think this is a ton of work. I don't think it's going to end with this session, even if the bill is changed to make the accommodations we've talked about. And it's reiterated and passed. There's going to be a ton of work related to that. And so how do you all envision we should make recommendations for how that work moves forward? Some of it may be outlined by the bill itself. Oh, hello, Senator. But clearly you're all experts on this. You're passionate about it. You've invested a lot of time, and we want to continue the conversations with you to help inform whatever may or may not, go forward this time. So I think those would be 2 good conversations, but open to comments from the group. Yeah, Tina.
Hi. Yeah. Equity, there's a big equity piece that I see in the bill, and that is the license to operate Psilocybin Service Center, Section 26, line 37. Oh, sorry. Okay, so maybe I just need to read this aloud and see if I'm understanding it correctly. So must ensure that the Psilocybin Service Center is located in an area that is not within the limits of an incorporated city or town. So it sounds like the service center cannot be in the limits of an incorporated city or town. And I just feel like there's, reading from Senate Bill 5660.
So yeah, so that you're reading from 5660. So 5660 is the template by which we are responding. It was not passed. So our work is to sort of take a look at that and say, kind of in response, how we view some of the language in that, and specifically for the state agencies, what our requirements were in the law. So to what I was saying earlier, I think that would be exactly the kind of thing that an equity subcommittee would look at and make recommendations for. So I that's my point, is that there are so many layers here that need to be discussed more intentionally than we have had the time to do, and led by people who are most impacted by equity decisions, that I think we need to just frame this group's best thinking about how that piece should go forward, because I see that as a separate parallel informing all of this piece. All right. So just want to get additional feedback from the group for those 2 ideas for the 2 final meetings of this group. Obviously, you are all welcome to do whatever you would like as a group, from the state facilitation kind of perspective, this, we are bound to what we have been told to do and funded for. So just want to put that out there for the group. And that's something that you can mull over the holidays, and we can, address it, but plan for the next meeting really to focus on what should the recommendations be to make sure that diversity, equity, inclusion considerations are front and center, whatever happens as this work goes forward. One veteran. Yes,
yes, front and center is good. Core.
Yeah. Veteran, yeah, and for people who want to access this, yes, veterans for sure. There's clearly a lot of work to do. Veteran access, sure. I mean, and again, I think that, and you bring in the VA, which is a whole federal level system of its own regulation. Lacey's going, yeah, and Christy's going, yeah, that's a whole different thing. So yes, again, please share your thoughts if you don't have any today. But we will plan to have a discussion on how to best thoughtfully move forward with equity considerations and discussions. Senator Solomon, I see you were able to join us just in the last few minutes. Anything, and this is recorded, so you'll be able to listen to it at your convenience, but anything you'd like to say to the group?
I'm just starting to have conversations with members of the committee. I don't want to box anybody in there in terms of the healthcare committee, but I'm glad we're working on this. And I'll just say, generally speaking, I'm optimistic, cautiously optimistic that we can move this bill.
Great.
And thank you very much for working on this and helping to perfect it. It's great to have a lot of eyes, a lot of expertise. It's a long bill. I've certainly done my best, but I think the bill is made better having you guys look at it.
And just one last thing I'll say, we will, the next legislative session starts on January 9th. That may not be a date you all have in your mind, but those of us who will be busy and responding to it, we know that date. And so we will do our best to schedule a time. It will be obviously probably during session. And I don't know, Senator Solomon, if given the point where we are now, you feel the need that we should try to meet early in session in case there are any adjustments. You've gotten a ton of feedback from folks about response, and DOH did an excellent job today outlining sort of the currency of where they stand in relationship to how 5660 was written in their recommendation. So I don't know if you have a sense of timing. I don't want to push the group, but I don't know if it would be of benefit to you to think about timing given the legislative session coming up or not.
So I haven't heard the DOH presentation, and I will listen to it because this is being recorded. My intention is to introduce the bill somewhat before session.
Okay.
Maybe 1 or 2 weeks before.
Okay, that's helpful. Paul, did you have a comment?
Yeah. Yes. And yeah. Excuse me if I'm missing some cylinders in this engine of discussion. But is it my understanding correct that for microdosing, which is non-intoxicating, a therapist would have to have 1,000 hours of training before they could recommend a microdose?
In terms of certification, we haven't. So I'm trying to figure out what the right training level for certification is, and that's not yet determined. So my understanding is that your question is based on a question that was put to the group recently. Is that right? In terms of what certification standards we should have and how many hours?
Well, it just basically, therapeutic dose means intoxicating dose, and this is what we're talking about for therapeutic use. A non-intoxicating dose, it does not affect your consciousness, doesn't affect your ability to drive, no sensorium, no intoxication. Microdosing still is not, from my understanding, is not being addressed, and would it be under the same controls, guidelines, and regulations as a macrodose, which is intoxicating? Can this group give some definition in, between the two, because something that is non-intoxicating does not, change your ability to drive and function, et cetera, to be categorized in the same as, 5 grams of Psilocybin cubensis, is just seems to be a very big logical disconnect. So I'd love to have this group at least, address the question or bring it to the forefront of further discussions. I'll go back on mute. Thank you.
I don't know if that was a question for me or to the group.
For whoever has the ability to articulate a response. Thank you.
I think whether or not this is, and again, this is kind of the will of the group. We have these two additional meetings, one of which is taken. I think that this group can decide. We will have met our requirements in terms of the proviso. So if this group feels, and whether or not it's part of Senator Solomon's bill, sort of the approach that we at Healthcare Authority have taken along with the Department of Health is, this is clearly a topic of huge interest. Whether or not everything is detailed and figured out with the bill as Senator Solomon puts it forward, there will likely be unanswered questions and additional pieces. And so I see this as an opportunity to surface those issues, whether or not they're included in this bill, because they are important conversations. And so I think having all of you at the table is an opportunity for us to say, here are the things that we didn't address that at some point may come to the fore. So I'm kind of being opportunistic, whether or not it's in the cards right now. We have the right people to have those discussions on this call. So that's sort of how I'm thinking about it.
Yes, this bill, not every issue has to be dealt with in one bite. It may or may not be, but we also have to look at what is politically possible. And so the other members of the legislature and what their tolerance is for change is a critical factor. And you're certainly welcome to speak with members of the healthcare committee. If I'm allowed to do that, I invite you to do that. I think I can say that here. It's been impactful so far. So, yeah.
I'll just mention, we've been tasked to writing a white paper for the DEA for adjustment to federal policy. That white paper from our team of 10 scientists will be completed around December 8th. Cool. We've been in contact with Tim Fenimore, who is coming down for our final inspection for DEA approval. He admitted that these laws were written in 1970. We don't know what we're doing. The DEA just came out and said that, please help us. So this policy recommendation paper will be finalized in the next 2 weeks or less. And I can share it, given the permissions from the DEA and from Tim, if appropriately, with this group. It will be an opinionated, informed white paper. So, but it's going to lay these cards on the table for policy consideration federally.
I see a hand, Jermaine.
Pardon, was that addressed to me?
I just wanted to speak briefly to the issue of intoxicating versus non-intoxicating doses and training and licensure requirements, because overall, licensed prescribing clinicians need their preparation for differentiating and making decisions regardless of the danger level of the drug. So the 1,000 hours of practice that I did before I got my ARNP license, it informed whether I prescribed someone Benadryl for sleep or whether I prescribed them Ambien for sleep. I still need to draw on the preparation. So I don't think that we want to point to the idea that if a drug is less intoxicating, the clinician will need less preparation. I agree with you that we don't want requirements that inhibit people from being able to practice. And in fact, in my own field, the 1,000 hours of supervised work prior to being licensed was dropped about 5 years ago, so that can be looked at separately. But I don't think we should try to look at it in the dividing line between the more serious the drug dose, the more preparation the person needs, because that level of training and preparation is required even to make those calls about how do you decide how serious or how intoxicating a dose would be useful to the person.
Thank you. I want to recognize that we are at time. I do want to raise to the group, if you could designate by thumbs up or whatever, hands, whatever. I think Paul raises a good point. Do we want to devote at least some of the time of one of the two meetings to a discussion about microdosing? If you think that would be useful and important, please demonstrate in your emoji boxes, as it were. I see it can't hurt. I see a couple thumbs here and there. Yes, okay. So thumbs, excellent. So let's plan that. We'll plan an equity discussion. We'll plan to revisit the topic of microdosing. Duncan's got a follow-up plan with Paul. And Mike, I'll let you end it up.
Oh, well, thanks, Charissa. Yeah, I think outstanding session today. And again, many thanks to Department of Health folks for giving that. I think it was an outstanding overview. And I look forward to kind of these next two meetings in 2023. And if there are additional thoughts, comments, as Charissa was saying, please don't hesitate to send those on to us as we kind of do some additional prep. And Paul, we'll look for that paper that comes out. If you want to send that out to the group too, we'll make sure that gets distributed, because I think that would be helpful to have as background. Okay, guys, thanks again.
Thank you all.
Great weekend. Bye.